accused person must be a substantial cause of the death, not an infinitesimal, not an insignificant contribution. Must be a significant cause. That's the de minimis rule. Okay? So in establishing the fact that the act of the accused person caused the death of the deceased, there is what we call causation. That is to say that the act of the accused person is the causa causae of the death of the deceased. However, I told you that there are certain instances in which the chain of causation can break, in which it can be broken. And I gave you the example of a year and a day rule, which I've explained to you that if death results from the act or injury caused by the accused person to the deceased, after 365 days or 366 days, as the case may be, then the chain of causation is broken. That is a year and a day rule, which I explained to you by virtue of section 314 of the Criminal Code. And I told you that it is now a relic of antiquity because under the English law, section 1 of the Murder, Abolition of a Year and a Day Rule, Act 1996, it has been abolished. And by virtue of the criminal law of Lagos State, it has been abolished, but it is still existing in our criminal code. So for the purpose of examination, if we ask you, if we give you a scenario where somebody stabs a person or causes an injury, and the person dies maybe about 367 days after, or let me say 370 days after, and we are now asking you whether the person is liable for the death of the deceased. You know, we want to test your understanding of the application of a year and a day rule. So if we say that it happens in Lagos, so a brilliant student should be able to say that by virtue of the criminal law of Lagos State, a year and a day rule has been abolished, and that the chain of causation is not broken. But if we now say, will your answer be different if the accused person is to be tried under the Criminal Code Act? Because the year and a day rule is still applicable, it's still in force under the criminal code. Do you understand what I'm saying now?
Yes, sir.
So you have to take note of all these minute details because they matter a lot. So I also gave you example of novus actus intervenens. Novus actus intervenens, as I explained to you, has to do with that, with an intervening act, you know, which is sufficient enough to discharge the accused person from liability. I gave you a case of Jordan, I gave you Smith, I gave you Holland. And I told you the problems about all these cases when you have cases that have almost similar facts and are being held differently. For example, in Jordan, you know, the court held that the chain is broken simply because there was poor medical treatment given, which resulted in bronchopneumonia. And as a result of that, that was broken. I gave you example of Ikono versus State, which led to leg amputation, you know, due to infection. But I also gave you Anna Smith, which also indicated bad treatment. And I gave you Holland, where they said it was not properly handled. But the court held that the chain was not broken. Okay? So that was where we stopped. You know, that was where we stopped. Novus actus intervenens can be seen in section 313 Criminal Code. When you talk of a year and a day rule, as I said earlier on, it is 314 Criminal Code. But novus actus intervening of certain acts is under Section 313 of Criminal Code. So the next factor under chain of causation is death, acceleration of death. This you can see in Section 311 of Criminal Code, acceleration of death. And what this simply means is a situation, there was a past question, a problem question, a hypothetical question, where somebody perhaps was stabbed and the person has lost a lot of blood and the person fainted, but he was not dead, and was being rushed to the hospital. And they engaged a driver who did night duty, who had actually not slept, to come and take the victim to the hospital under a case of emergency. And as the driver was carrying the victim to the hospital, who has fainted but was still alive, you know, he slept off on this channel and he hit a very big Iroko tree. The victim died immediately. Perhaps if he had made the hospital, he would have lived, or he would have still died. Maybe he would have died 5 minutes later, even if accident. But the victim died. In that kind of situation, that is an acceleration of death. Somebody that would have died ordinarily at a later time, but because of your intervention of certain acts, you accelerate that person's death. So in that kind of situation, the chain of causation is broken. Are you hearing me? Hello?
Hello,
Yes,
sir.
sir.
Section 311 of the Criminal Code makes any person who hastens the death of another through act or omission while the victim is already laboring under some disorder or disease arising from another cause which might have killed the victim, but for the accelerating intervention of the defendant's act or omission. So on this, you see the case of Uyo versus AG Bender State. Uyo and AG Bender State is 1986. 1 NWLR, part 17 at 418. Uyo and AG Bender State, 1986. 1 NWLR, part 17 at 418. Then you see also the case of R versus Dyson. R versus Dyson. Dyson is spelled D-Y-S-O-N. 1908, 2 KB, 454. 1908, 2 KB at 454. Is that clear?
Yes, sir.
Yes.
Okay.
So
the
can you come again with the last?
Which one? R versus Dyson? Is it R and Dyson? Hello?
Yes, sir. R versus Dicey.
I said 1908, 2 KB at 454. 1908, 2 KB, 454. Okay. So the next factor.
Yes, sir.
The next factor to be discussed under chain of causation.
Yes, sir. Yes, sir.
Hello?
Yes,
hello?
Sir. Yes.
Hear you, sir.
Okay. The next factor under chain of causation
yes, sir. Is that versus Dicey, sir?
Huh?
We can't hear you, sir.
Okay. Are you hearing me now?
Yes, sir.
Yes, sir.
Okay. You had the citation of.
Yes, sir.
Okay. So I said the next factor under aggravation of wounds. Aggravation of wounds. The next factor, under chain of causation is death resulting from aggravation of wound. Death resulting from aggravation of wound. You know, for example, when you see somebody, this is very interesting. I'm going to give you the case of R versus Wall here. R versus Wall. And this situation is almost similar, to the case of refusal of medical, treatment or medical.
R versus what?
R versus Wall. I will soon give you. I'm just, giving you a background. You see, aggravation of wound is a situation whereby, for example, if the accused person stabs the deceased, and the deceased is addicted to certain substance which can aggravate his situation and make the recovery to be unrealistic, which if he abstains from it, and doctors have advised, abstain from this if you want to live, but the patient insists and continues taking it. And because of that substance that the person is ingesting, the person dies. And if he had complied, he would have lived. But the court held in such cases that the chain of causation was not broken. So it is an example of taking your victim as you find him. You take your victim as you find him. So that's another interesting case. So where the accused occasions an act or omission, where the accused occasions an act or omission to compound in one way or the other, and the deceased dies as a result of such aggravation, and the deceased died as a result of such aggravation, the accused shall not be absolved from liability due to the intervening and supervening acts. Where the accused occasions an act of omission to compound in one way or the other is condition, and the deceased died as a result of such aggravation, the accused shall not be absolved from liability due to the intervening and supervening events. So in R versus Wall, Wall is spelled W-A-L-L. R versus Wall, 1802, 28 STR, 28 STR, 51. The governor of a colony sentenced a soldier to illegal flogging. The governor of a colony sentenced a soldier to illegal flogging, and the soldier became ill. The soldier became ill.
To what, sir? To what flogging?
Sentenced a soldier to illegal, opposite of legal, illegal flogging. And the soldier became ill. But the illness was getting aggravated by his alcoholic consumption. The soldier was consuming alcohol, and it was aggravating his illness. He was told not to drink alcohol pending his recovery, but he persisted and died. He was told not to drink alcohol pending his recovery, but he persisted and died. The court held that the chain was not broken. The court held that the chain was not broken. So the next factor under chain of causation is where death results from threats of the accused person. Threats. Causing death by threat. Threat. Causing death by threat. A person who, after applying threat or intimidation to another, a person who, after applying threat or intimidation to another, causes that other to embark on an act or omission, causes that other to embark on an act or omission A person who, after applying threat or intimidation to another, causes that other to embark on an act or omission which led to his death, is liable for killing him. Section 310 Criminal Code provides for that. So in R versus Hayward, Hayward is spelled Hayward. In R versus Hayward, 1980, 21 Cox. Cox is COX. 21 Cox, COX. Criminal case at 692. At 692, there was an altercation between the accused and his deceased wife. There was an altercation between the accused and his deceased wife, upon which he threatened to deal with her. The deceased took to the street out of fright. And the accused pursued her. Shortly thereafter, she fell down and died.
Sir, can you start from there was an altercation again?
There was an altercation between the accused and his deceased wife, their husband and wife, upon which he threatened to deal with her. He threatened that he would deal with the wife. The deceased took to the street, that's the wife, out of fright, fear. And the accused pursued her. Shortly thereafter, she fell down and died. Medical evidence revealed that she died as a result of a defective gland. Medical evidence revealed that she died as a result of a defective gland, which could cause death as a result of fright. Medical evidence revealed that she died as a result of a defective gland, which could cause death as a result of fright. The court applied the eggshell theory, egg as in E-double-G, shell, S-H-E-double-L, then theory. Eggshell is fragile. If anything slightly hits the shell of an egg, it breaks. Are you aware of that?
Yes, sir.
So eggshell theory, which simply means take your victim as you find him. And found the accused guilty. The court found the accused guilty. The court held that it was unnecessary to prove actual physical violence. It was unnecessary to prove actual physical violence or knowledge of the wife's condition. Perhaps the accused person was not aware that the wife had a defective gland, which could cause his death, her death by running. But the court says it's material. The knowledge of a medical condition is immaterial, and it's not also necessary to be physical violence. There is no evidence that the accused person hits the deceased with any object or with a blow or with anything. It was just pursuing her. And that created fright, fear, in the mind of the deceased as she fell down and died. And the court held the accused person guilty of murder and held that the chain was not broken. Okay, let me give you an example of where we have tested students' knowledge on this area before. And there was a question, hypothetical, that we set in a particular session where somebody was owing somebody and the creditor went to the house of the debtor. And while the creditor was inside the compound of the debtor went to go and loosen his Assyrian dog. And the Assyrian dog was trying to face the direction of the creditor. And the creditor, being afraid of the dog's attack, attempted, because the gate has been locked, so attempted to jump and escape. Then he fell headlong and died. That was a situation where we tested student knowledge of causing death by threat. The debtor never touched the creditor, but he let the asset, which created fear and fright in the mind of the creditor, and a bill for the creditor to escape. The creditor died, and the court held the debtor liable for the death of the creditor. There was another case. Hello?
Which case is that? The one you just
No. I said we have used it to test students' knowledge in previous examinations. It's a past question.
Okay, sir.
But it's in four words with R versus Hayward. You know, the principles are the same. The facts are not the same. You know, but when we want to test your knowledge, we won't give you the same facts. We want you to use your sense to apply it. There was another case. There was another case where we tested students' knowledge of this aspect of causation. A Muslim, and this was a situation where we were trying to know whether a student will be able to differentiate between murder and manslaughter. A Muslim was sitting beside the window of a bus. Then there was a guy sitting by the right side of the Muslim who was taking alcohol and was drunk. As the bus was moving, he wanted to throw off. And he put his mouth towards the direction of the window, since he was not the one sitting directly by the window. Then the vomit fell on the body of the Muslim. And you know, Muslims detest alcohol. I'm talking of genuine Muslims. So they detest alcohol. They detest something like pig meat, pork, or whatever, or dog, all those things like that. So the vomit poured on the body of the Muslim guy that was sitting close to him. So the guy drew out his dagger, wanted to stab, the person that vomited on. And as the guy was trying to dodge the dagger, he attempted to escape through the window of a moving bus. So he hit his head on the floor and died. The guy never stabbed him. So that's an example of causing death by threat. But in that kind of situation, we also tested students' knowledge of manslaughter. Because though we have not taken manslaughter, but when we get there, we are trying to find out whether vomiting on a Muslim is enough to make a Muslim to lose his control to such extent as to stab, to such extent as to attempt to stab, the deceased. So there are different phases of the case. When we test students' knowledge, not only on a particular principle, we try to lump about 2 or 3 together, so you'll be able to distill and identify the issues raised in that hypothetical question. Are you getting me?
Yes, sir.
Okay.
Yes, sir.
Okay.
Yes, sir. But sir, I have a question concerning what you just said, sir.
Yes, what's your question?
Okay, my question is that to me, causing death by threat, I initially thought that maybe it's just by words. But based on these examples that you're giving, are you trying to imply that, okay, even if somebody just acts and it seems to intimidate another person, that is also death by threat? Is that what you're saying, sir?
Intimidation, yes, it's by threat. If the intimidation can make that person to take certain steps which result in his death. Are you following me?
Yes,
Hello?
sir. Yes, sir.
So that is the issue. That is the issue. You know, that is the issue. But you see, there are instances of in like, for example, there is this case of R versus Uwaoke. It's a very old case. And if you threaten somebody with juju, and the person maybe in a bid to escape falls down and die, you know, that can also be an example of death by threat. But you see, it's a controversial aspect of the law because the law does not actually recognize, voodoo. No, that is the problem. But there have been cases where the court held, it constituted fear in the mind of the deceased, and that as a result of that, the accused person will be liable. That there is no break in chain of causation. That's like what happened in R versus Uwaoke. Somebody threatened somebody with juju, and the person was trying to avoid the consequence of that and died. Supernatural means juju leading to somebody committing suicide. They said there is no chain, no break in the chain. But you see, the problem with that again, like I asked you maybe during the first class, if I say that somebody will die by midnight, and the person eventually dies by midnight, and when the person gets home, he told her husband, somebody threatened her that he will die by midnight, but that is an empty threat. But by 12 midnight, the person shouted, "Oro," and dies. Can the wife go to police station the following day to report a case of murder? Hello?
No, sir.
No,
No,
sir.
sir.
Simply because when you are talking about causation, there must be a causal relationship between the act of omission of the accused person and the death of the deceased. That is very important. You see, all these instances we are giving you, there are causal relationships. Causing death by threat, aggravation of death, aggravation of wound, rather, acceleration of death, there are causal relationships. So the last but not the least is
Sir.
refusal.
I have
Yes.
a question.
Yes.
I have a question on aggravation of wound. Does this only apply when the aggravation is caused by the victim?
Yes. When the aggravation is caused by the victim, he engages in doing certain things that will make his situation to be worse rather than to improve. You see, what they are trying to tell us there is that it is not a defense for the accused person to say if he had yielded to medical advice, he would have lived, and that he's no longer liable for his death because he disobeyed the medical instruction. No, you check your victim as you find him. Eggshell theory. That is it. I don't know if you understand what I'm saying.
Yes, I do. Thank you, sir.
So the last but not the least, which is also
Please, sir, I have a question. Sorry to
yes,
interrupt you, sir.
What's the question?
Please, sir, I want to ask that threat causing death, must it be with a dangerous objects or something? Can it be with like maybe the person has a
I've
fear
given
of
you
maybe
three,
like doll babies
I've given
and
you three. I've given you three examples.
okay.
The example in Hayward, was that the man threatened to deal with the wife. You see, in Hayward's case, they didn't say he was armed with any dangerous weapon. They said he was pursuing her. It may be, maybe he wanted to give her an impression that he will beat her or he will slap her. You know, some women can be so afraid of even beating, of even, don't hit me, don't assault me, something like that. He was not armed with weapon. He was just running to escape, what the man said, that I will deal with you. But unfortunately, and unknown to the man, the woman had a defective gland. You see, it is a subjective issue. It is not a defense that assuming the woman was healthy, if she had died in that situation, the man would have been absorbed. No. It is not a defense that it's because she had a defective gland, otherwise she wouldn't have died. No. Take your victim as you find it. So, in that kind of situation, it's an example, but I gave you more examples that were more pragmatic. I gave you the example of somebody who let loose an Egyptian dog, and out of fear, a creditor that has come to demand for his money, trying to escape from the dog's attack, died. And the court held that the owner of the dog killed the man, because the dog unleashed threats to the person who was trying to escape. Then I also gave you an example of somebody who vomited on a Muslim, and the Muslim felt enraged by virtue of his religion. They detest alcohol, and he brought out a dagger. You can see that dagger is different from setting loose a dog. But both of them can generate fear. Both of them can precipitate urge for escape. And in Hayward, the man was just pursuing the woman, and the woman died. He fell down. She fell down and died. So these are three examples. So when you see this kind of scenario in your exam questions, you will know the direction of flow. Are you following me?
Yes, sir. Thank you, sir.
So refusal of medical treatment. Refusal
Sir,
of medical.
I have a question on the example that you just gave. Sorry to
Yes.
interrupt. You said the example you gave of the Muslim man and the one of somebody vomiting on him. Would the provocation avail serve as a defense for that scenario?
Yes.
Like the
Like I
abrogation,
told
does that
you,
deny the cause
like
chain of
I
causation?
told you, we have not taken provocation. We have not taken manslaughter, rather. Because manslaughter will take it after murder. Then we'll take defense of provocation. But just for your benefit, it depends on how you argue it. But, we usually encourage analytical argument. If you look at that case, it was not a mistake or coincidence that we said the person is a Muslim. We could have said the man sitting close to him without disclosing the religion. But for us to have said a Muslim, for us to have said alcohol, vomit, this is what a Muslim detests. So it will avail the defense of provocation. But if it had been a Christian, the answer may not be the same. Because we will ask you, assuming Jimon is a Christian, will your answer be the same? So that's why you see a brilliant student, a dollar will probably say yes, because the alcohol is smelly, this and that, vomit. But you see, you need to look at the subjective elements there. What a Christian can tolerate, a Muslim may not be able to tolerate because of that religion. If you put leaf in your mouth in the presence of a deaf person, please, you can try it. Come and tell me what happens to you later. the deaf will attack you. Because to the deaf and dumb, putting leaf in the mouth is abuse to them. Whereas to somebody that is not deaf, it has no meaning, no implication. I don't know if you understand what I'm saying. Hello?
Yes, sir. We understand.
So that
hello,
is
sir.
You
why
understand, sir.
when you have problem questions, read in between the lines. Don't just rush. Every fact given has implication. Every fact given has implication. You understand now? Just to test your understanding of that principle.
Hello, sir. Hello, sir.
Yes.
So,
Can you hear me?
Yes.
Hello, sir. Good morning, sir.
Yes. Yes.
Just before you move ahead on the point you just made regarding the question that was asked. So now, like for me, the way I perceive this scenario is that will it now be reasonable to raise the defense of provocation because someone,
To raise what?
so like the defense of provocation, someone, you said the scenario state that there was like a vomit of alcohol. So was the reasonable thing to do in that circumstance is to bring out a dagger, not even a blow? So like, I'm just
Muslims, especially the Fulani that are rearing cattle, they are used to having dagger. Are you not aware of that? They don't see it as a big deal. It's customary for a Fulani or Hausa person to have dagger. You
thank you for
understand?
putting
Uh-huh. So, see, the way we will examine you in that kind of situation, we'll ask you to consider the criminal liability of the person who brought out dagger. Eh? Then we'll now ask again, B, does Mr. So, how we can say, consider the likely defense open to so. So that is where you are going to discuss provocation. I don't know if you understand what I'm saying now.
Yes,
But
I do,
the
sir.
A part,
Please come again.
the A part is examining you on murder. The B part is examining you on defense of provocation. So it is for you to argue whether it will avail or to not avail. And if you are saying it will avail, you state your reason. If you are saying it will not avail, you state your reason.
Excuse me, sir.
Are you following me now? Yes.
Yes, sir. So if he does that in Lagos, if the Fulani guy brings out the dagger, and does that in Lagos, will the defense of provocation still avail him? Since it's not in the north.
It is not dependent on where the person is located, the location of the accused person. It is dependent on the religion or peculiar circumstances of the person, not where the person resides. Are you following me now?
Yes, sir.
So we won't ask you whether if it happens in Minna or it happens in Lagos. We only ask you whether if the person is a Christian, will your answer be different? Because it has to do with religion. It has to do with religion.
Okay, sir. Thank you, sir.
Okay.
Hello, sir.
That's
Hello,
what
sir. Hello, sir.
Yes.
Good morning, sir.
Good morning.
Sir, I have a question on something like similar to that Hayward's case, but not like when the cause of death is different. Like, for example, let's say the man, he threatened like he'll deal with the wife, but then he didn't chase the wife. The wife like just went outside to like get away from the man, but the man didn't chase. And then when she went outside, like she was agitated, her body was shaking, and she was like she was scared, sha. And then when she went outside, let's say she met her sister or something, and her sister asked her what was wrong. She said that my husband said that he's going to deal with me. So I'm trying to get as far away from the house as possible. But he's not chasing her. And then wait there. In that scenario, the husband would not be liable. In Hayward's case,
what actually caused problem for him was because the woman was running and he was pursuing her. Somebody who has a defective gland does not have that liver to undergo strenuous exercise. So it was the running that she was running that made her to fall down and die. Okay? And that is why they say it is immaterial whether the husband was aware of her peculiar health condition or not. So that is the issue. The one you are talking about now, that the husband just threatens her without more, and the woman started shivering and this and that, it may not avail. Because the fact of Awar's case shows that he was pursuing her and she fell down. So we will not ask you questions that will confuse you. We will not ask you questions that will confuse you.
Okay, sir.
Hello,
Thank you,
sir.
Are you getting my point? So, refusal of medical treatment. This is the last one under chain of causation. Refusal of medical treatment. So this has to do basically with people who belong to certain sects or religion and who have peculiarity. Well, there was a time we set a question and we said somebody was an occultic guy. It belongs to a particular cult and Ifa worshipper or whatever, but that the religion prevented them from undergoing surgery. But if he had submitted to surgery, he would have survived. That kind of situation, the chain is not broken. You know, but the case that usually comes up here is the case of Al versus Blau. Al versus Blau, I'll give you, you know, which has to do with a Jehovah's Witness. And you know, these Jehovah's Witnesses, they detest blood transfusion. So in that case, the deceased resisted blood transfusion and he died. A medical report is that if she had taken the transfusion, she would have lived. And the court held that it was not a defense, that if he took the transfusion, he would have lived, that you should take your victim as you find him, and that the chain of causation was not broken. Are you following me? Okay.
Yes.
Are you there? Chain of causation is not broken.
Yes, sir, please. But what is the case that you mentioned, sir? R versus what?
Just be patient. Chain of causation is not broken where a victim refuses medical treatment and dies. Chain of causation is not broken where a victim refuses medical treatment and dies. It is immaterial whether the refusal is based on any religious or occultic belief. It is immaterial whether the refusal is based on any religious or occultic belief. If the refusal to take medication made the victim to die, the accused is liable for his death. The refusal to take medication or to accept transfusion made the victim to die, the accused is liable for his death.
So the accused would be which person in this case?
The accused is the person who inflicted injury on the deceased, and in which the deceased refused to take medical treatment and dies. So you are talking in terms of accused and the deceased.
Sir, I have a question.
Yes.
Okay, sir. So does it only apply to people that have certain religious beliefs, or it applies to everybody, sir?
Religious, occultic, or maybe personal beliefs. I have a client, for example, I have a client in Egbeda, it's a woman. She will be in her 60s. That woman does not take anything orthodox medicine at all, not even Panadol. She doesn't take anything orthodox medicine, and she doesn't take injection. Anytime she has any ailment, she believes in all these what do you call them? Alternative medical therapy. You know, all these Chinese herbs and so on. That's what she takes. So one day I told her, look, this is a very high risk. Why can't you do tests? And she said those people also do tests, but when they do tests, they have their own drugs that they prescribe. You know? So God forbid, if that kind of woman requires surgery, she won't do surgery. You understand? She won't take blood transfusion. So somebody should be careful. Assuming you now have issue with that kind of woman now, then the person is in trouble. Because she has a personal belief that she doesn't take orthodox medicine at all. So there are people like that. So in this case, some people can have occultic belief, like the example I gave to you, which was a past question. The guy was an occultic guy, and I think somebody used a vehicle to hit him, and you know, he lost blood. No, he required surgery. He was supposed to do surgery to save him, but his occultic belief, he tested surgery, and he died. So you can see the case of Al versus Blau has to do with refusal of blood transfusion. Don't think that if we want to examine you on this particular principle, we will also give you a case that has to do with blood transfusion. It's a Jehovah's Witness, but in that case, we said occultic person. You know, Ifa is a worshiper, Ifa worshiper. You know, so you have to make your mind to be open so that you can distill facts. Don't expect that it's only when you see blood transfusion or you see Jehovah's Witness, that's when it is applicable under the visa of medical. No, it can come in any form. It's for you to be able to have two and two together to get four. So if the refusal to take medication made the victim to die, the accused is liable for his death. So in Al versus Blau, Blau is spelled B-L-A-U-E. B-L-A-U-E. Al versus Blau, 1975. 3 AER. 3 AER at 440. 440. Aram Blau, 1975, 3 AER 440. Where A stabbed the victim, A is the accused person now, stabbed the victim, who was a member of Jehovah's Witness sect. And who refused blood transfusion preparatory to a surgery. B refused blood transfusion preparatory to a surgery because of her faith. Medical evidence revealed that she could have lived if she had accepted the transfusion. She died as a result of bleeding resulting from the stab, and the court held that the chain of causation was not.
Too fast, though.
Okay, let me take it again. In Al versus Blau, A stabbed the victim. A stabbed B, the victim, who was a member of Jehovah's Witness sect, and who refused blood transfusion preparatory to a surgery. Refused blood transfusion preparatory to a surgery because of her faith. Because of her faith. Medical evidence revealed that she could have lived if she had accepted the transfusion. Medical evidence revealed that she could have lived if she had accepted the transfusion. She died as a result of bleeding. She died as a result of bleeding arising from the stab. She died as a result of bleeding arising from the stab. The court held that the chain of causation was not broken. court held that the chain of causation was not broken. So on that note, we have concluded actus reus of murder. Now we want to proceed to mens rea of murder. Like I told you, mens rea is the mental element of murder.
Hello, sir.
Yes.
Good morning, sir. Please, I have a question. My question is if the action of the accused was actually a publication that tarnished the image of the deceased, probably making the deceased to commit suicide, which resulted to his death, would it still be considered a threat?
It depends. It depends, but that may not come under. It may not come under this per se, because you see, there is what you call demanding with menaces. I'm not sure whether, I don't know whether you have been taught demanding with menaces. For example, there was a question I set recently. We have two friends working in a bank. Two friends working in a bank were living in the same house. And one of them was impotent. But it was not known to everybody. It's only known to the friend. So one day they were going to watch the football match at the nearest stadium. They were taking a walk. And one asked the other, the impotent guy, that if he does not give him 50,000 naira, I will tell everybody in the bank about his potency status. So out of fear, because the guy didn't want people to, the moment they know that he's impotent, they won't be able to go to work again. They have to pay the money. So for that, if they say you should consider the criminal responsibility, that is demanding with menaces. But I didn't push it to the point of death. I pushed it further. I pushed it further to say that when they went further, they saw a Prado Jeep of 2024 model. So one of them said it's 2018. The other said it's 2020. They started arguing. Then the next thing was that one slapped the other, and the other held his shirt in the public. That's an offense of affray. So I said, consider criminal liabilities of the party. So in that scenario, you can see the offense of demanding with menaces. You can see the offense of affray. Okay? However, if there is a publication that led to somebody's death, it may not be very easy to classify it under causing death by threat. I don't know if you are understanding what I'm saying.
Yes,
it is a publication that is deleterious, and somebody now goes to the extent of committing suicide, it may not come under causing death by threat. It may not come under causing death by threat. The only thing is that it may be subjected to reasonability.
Your mic is muted, sir.
Hello, are you hearing me?
Yes, sir.
Hearing me now? Yes. It may be subjected to reasonability test. Whether a reasonable person in the shoes of the deceased will have ended his life because of that publication or not. And there is also element of remoteness of causation, remoteness, whether it is enough, to make somebody to die. So, but it doesn't come under these 6 factors that we are talking about. Yeah. Are you following me?
Yes, I am.
Okay. So quickly, when we talk about mental elements of murder, what are we talking about? Okay, from the outset, we have told you that actus non facitum, nisi mens rea. That is to say, an act alone does not make a person liable or guilty for an offense unless it is accompanied by a guilty mind. So, having discussed the actus of murder, now we are to discuss the mens rea of murder. And the mens rea of murder is contained in section 316, subsections 1 to 6 of the Criminal Code. Section 316, subsections 1 to 6 of the Criminal Code. And this is a section that enumerates the various intentions that the defendant must formulate to be culpable for murder. Section 316, subsections 1 to 6, enumerate the various intentions which the defendant must conceive or formulate to be culpable for murder. Like I said, this is in line with the maxim, actus non facitum, nisi mens rea. So the prosecution must prove guilty intention. The prosecution must prove guilty intention. But the problem at this juncture is, how do you prove a man's intention? Even the devil does not know the mind of a man. And the state of a man's mind is like the state of a woman's digestion. So it is difficult to prove man's intention. So in most cases, it is inferred. In most cases, intention is drawn from inference. It's drawn from inference from the nature of the act. In most cases, intention is inferred from the nature and circumstances of the act or omission. So in the case of murder, it can be actual or direct. It can be actual or direct, and it can be inferred or indirect. It can be actual or direct, that's intention, and it can be inferred or indirect. So intention is actual. Intention is actual, where the accused set out to kill the deceased, and in the process, the accused killed the victim or another person. Where the accused sets out to kill, and the person actually dies as a result of the accused, action, or another person dies, So the cases of there was a case where the husband wanted to hit the wife, with pestle, and the wife was carrying a baby at the back. So the pestle hit the head of the baby, and the baby died. So in that kind of situation, it is not a defense that he did not intend to kill the baby, that it is the mother that wanted to hit. So if you intend to kill a person or another person, and that results, you are liable. So that was their saying here. Aside it can be inferred where circumstances of the case disclosed or indicated that the accused intended to kill the deceased or any other person. Then importantly, or to cause grievous bodily injury. Or importantly, to cause grievous bodily injury. To cause grievous bodily injury. According to Bangboshe, according to Bambushi, not the daughter that is with us, the mother, who is a senior advocate of Nigeria and the deputy vice chancellor of University of Ibadan. According to Bambushi, he suggested the following parameters in inferring whether intention is formed or not. He suggested the following parameters in inferring whether intention is formed or not. Number one, weapon used, the type of weapon used. Hello, are you there?
Yes, sir.
Yes, sir.
Yes, sir.
The type of weapon used, weapon. She said that there's a distinction between using a cane on a person and a shovel or sharp axe. There's a distinction between using a cane on a person and a shovel or sharp axe. So in the case of Igago versus State, Igago is spelled IGAGO versus State, 1999, 12 SCNJ at 140. 12 SCNJ at 140.
Sir, please come again.
Igago versus State, 1999, 12 SCNJ 140. Igago versus State, 1999, 12 SCNJ at 140, where the appellant hit the deceased head with shovel. The appellant hit the deceased head with shovel, and he died on the third day. He died on the third day. The court held that the use of lethal objects, and dangerous weapons, lethal objects and dangerous weapons may lead to the inference that the accused intended to kill or cause grievous bodily harm. So by the time we start examining the subsections of Section 316, you will see that it is not only intention to kill that qualifies you for being guilty of murder. If it can be proved that you also intend to inflict grievous bodily injury or harm, then you can also be inferred to have formulated an intention to kill. So it's not a defense that I only wanted to wound him, I didn't intend to kill him. The distinction between the two, the borderline, is so, the distinctive line is thin between when you intend to cause grievous bodily harm and when you intend to kill. So both suffice. Number two, part of the body struck. For example, if you use object to hit somebody in the chest, where the heart is, or the head, it will not have the same effect as if you use that same object to hit the person at the leg.
Sorry, we didn't get number two.
Are you hearing me? Number two, part of the body struck, past tense of strike. Part of the body struck. I said, for example, if you use an object to hit somebody on the head or on the chest, where the heart is, it will not have the same effect as if you use that same object to hit the person at the leg. People hardly die from leg injury. For chest, head, or stomach, those are areas that suggest that you intend to kill. But if you hit at the leg, you may say a reasonable person will not expect that death will result from injury to the leg. So part of the body struck. See the case of Aga versus State. Aga is spelled AGA. Aga versus the State is AGA, 1976. 1976. 7 SC at 173. Aga and the State is 1976. 7 SC at 173. Where
The thing
they
is
are
that,
accused.
sorry, sir,
Yes.
we have another class now.
Okay.
Yes, sir.
So okay. So just remind me during the next class that we stopped on part of the body structure.
All right, sir. Yes, sir.
Stop part of the body structure. Okay. It's all right. Enjoy the rest of the day.
Thank you, sir.
Thank you, sir. Thank you, sir.
Yeah.
Thank you, sir.
Thank you.
Okay, you're welcome.
Thank you, sir.
Yeah. Yes, who is there? Who is there?
Please, I have a question.
11 o'clock.
Sir, I have a question.
Yes. Please, can you call by 11:30?
Hello, sir, I have a question.
I think this class is over. Is it not criminal law class?
Yeah, it's over. Some people went for their other classes.
It's
So I
over.
just thought I
I'm trying to switch over to criminology. I also have criminology from
okay.
9:30. Sorry.
Okay, sir. Next class.
I will take the question next class. Just remind me.